Hello, doctor. How are you?
Good, yourself?
I'm good. Do you so solemnly swear to affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, and you are welcome to testify with or without your mask.
I'll do it without.
Okay. Mr. Fitzmartin, you may begin.
Thank you, Judge. Can you please state your name?
Jeffrey Barnard, B-A-R-N-A-R-D.
And how are you employed?
I'm the director of the Southwestern Institute of Forensic Sciences and the chief medical examiner for Dallas County
How long have you held that position?
since 1991.
And so I'm assuming then that you are a doctor.
I am a medical doctor.
All right, tell me about your training and experience to be a medical doctor.
I attended Texas A&M University and received a Bachelor of Science in Medicine degree. I attended Texas A&M College of Medicine and received my MD degree. I served a one-year general surgery internship at Scott and White Hospital in Temple, Texas. I served a 4-year combined anatomic and clinical pathology residency at Scott and White Hospital, also in Temple, Texas. I served a 1-year fellowship in forensic pathology at the medical examiner's office in Suffolk County in Long Island, New York. I'm board certified in anatomic pathology, clinical pathology, and forensic pathology. I'm a diplomat to the National Board of Medical Examiners. I have a license to practice medicine in the state of Texas. I've been licensed in New York. I worked as an emergency room physician on a part-time basis during my residency and fellowship. I'm also professor of pathology at University of Texas Southwestern Medical Center, and I'm the current chairman of the Texas Forensic Science Commission.
Now, Southwest Institute of Forensic Science and the medical examiner's office there that you run, is it a teaching environment there at that establishment?
It is.
And tell us about that and your role in that.
Yeah, so as part of the Institute, which is both the medical examiner's office and the criminal investigation laboratory, we also have a fellowship in forensic pathology. Similar to what I did in New York, we have a similar program at the medical examiner's office here, whereby an individual who has the appropriate qualifications spends a year training and doing autopsies under the supervision of all the medical examiners.
And we heard earlier from Dr. Travis Danielson. Was he filling one of those roles with his time here at the medical examiner?
Yes.
And he testified about an autopsy that he performed on a Lou T. Harris in this case. Did you supervise him in that autopsy?
Yes, I was the supervising pathologist on that particular individual case.
Now, you might not have supervised him on all of his. You have other medical examiners there at your office.
Right, we break it up to, there's an individual each week who's in charge of supervising the fellows during that week, and that was my week.
Okay. And so you were there and participated in the autopsy of Lou T. Harris.
Correct.
Now, I want to direct your attention first to some of the findings that were found in Ms. Harris's case. We saw in State's Exhibit number 223 that the last page of that, the first signature on there is Travis Danielson. Is that right?
Yes, sir.
And the second signature is yours.
Right, and that by definition is the person who's the supervising medical examiner.
And then you go down, and the rest of the medical examiners that were on staff at that time, did they review the findings? There we go. Did they review the findings that are found by you and Dr. Danielson and sign off on the autopsies as well?
Right, they reviewed the report. They may have reviewed all the photographs. Some of them may have seen that live at the time of the autopsy, and then they agreed with the cause and manner of death and signed the report.
Okay. And so we had heard last couple of days, State's Exhibit number 208, in Ms. Harris's face and showing these the petechia that are existent in her face. Is that what we're seeing in 208?
Yes, on both the right and left side.
And Dr. Bernard, have you ever had the occasion to do an autopsy on an individual prior to Ms. Harris that had been smothered.
Yes, both children and adults.
Okay, and how do you know in those cases that the individual had been smothered?
Well, in the case of the children, one of them, there was a confession and the airway was obstructed by a plastic bag. The other was my decision based on finding the infant face down in a pillow with bruising on the back of the head, really consistent with fingerprint type impressions, though I couldn't say that for sure, but that was my conclusion, my determination. The other elderly individual who was a smothering, that case had flora petechiae on the face and neck, and that person was smothered by her spouse, who then wrote a note listing that he had smothered her with a pillow, and then he overdosed himself. So we knew de facto, based on his own statements, what he had done.
So through your training and your experience then, when you saw the state that Ms. Harris was found in, were you able to confidently call this a smother?
Yes, but you take into account the entire picture. With the investigative information we had at the time, the findings that were there, that was totally consistent with the smothering.
And I kind of jumped ahead. I guess what my point is, the state of the body in and of itself, the indications that you saw there would be consistent with the other things you found in a smothering case.
Yes.
Maybe not enough for you to call it a smothering case without other information.
Yeah, well, the petechiae are florid and a little more so than some of the other things that can cause it. But in general, in isolation, you wouldn't call it straight on that.
Sure. So, State's Exhibit number 211, looking at Ms. Harris's cheek. Also there, you were seeing on the left-hand side, you'd see that same petechia.
Yes, sir.
Now, she was found on her left side, kind of facing down. And is there a significance then to State's Exhibit number 214 in seeing that on her right side, we still see that petechia existed? Tell us
right.
about
Yeah. So if you're trying to compare what may be gravitational effect or positional effect, the left side being down, those can be embellished maybe more just based on the fact there's some gravitational effect. But now you've got some on the right side too, and then again you take in the whole picture and it's totally consistent with the smothering.
And then were you also made aware then that of the, you said that you used other information in that Mr. Chemirmir was, or there was an individual that was arrested with her possessions, and that she had been alive just 2 or 3 hours before that in the same location with that individual. Does that type of information go into your determination then of how to call it the manner and means of the deceased?
Well, you have to put the whole picture together. So part of making a determination of the cause and manner of death is taking into account your findings, what scene findings may be present, what investigation findings may be present before you make a conclusion.
And you use that in this case?
Yes.
And was it the manner and means of homicide by smothering?
Yes.
So basically, as a medical examiner, you're not only a doctor, you're also somewhat of a detective or investigator.
Well, I don't know whether that's a compliment or an insult, but I guess maybe you could put that in. But yes, there are components of that into it.
I promise you, I term it as a compliment. I promise you that. Okay, so at some point in time, were you asked to look back at an unattended death of an individual by the name of Mary Brooks?
Yes.
And were you asked? Now, Ms. Brooks you were not able to perform an autopsy on Ms. Brooks.
That's correct.
At the time that she was found, how did you all, or as far as that investigation, how was her death classified at that time?
Originally?
Yes.
It was determined at that time with the information available that it was a natural death.
Later were you provided through the Richardson Police Department more information as this investigation went on?
We were notified that there was further investigation going on, that there may be more involved than just what we originally thought had occurred.
Okay. The jury has seen photos from the scene of Mary Brooks' house. Were you shown those?
Yes.
The jury has seen a body-worn camera from Officer Harris going over the investigation of Miss Brooks's body. Were you shown that, and did you go through that?
Yes.
The jury has heard about cell phone data that places Mr. Chemirmir's phone in the location of Mrs. Brooks's house at the day before she is found. Were you aware of that?
Yes.
The jury has heard that a Nissan Altima, which was driven by Mr. Chemirmir, was seen leaving and following the vehicle of Mrs. Brooks. Were you made aware of that?
Yes.
Judge, I'm going to object to the nature of these questions. He's asking what this jury was made aware of, and at the time of him making or reviewing these reports, he had no idea.
No, I'm asking him, I said the jury has heard of this. Were you made aware of those facts? I wasn't saying that he's made aware that the jury's heard of this. I'm saying there's cell phone data, there's videos, there's all this. Was he made aware of those in his investigation of Mrs. Brooks's case? That's my question.
Then I would ask him to phrase it properly, Judge.
Okay. So, objection overruled, and if you would just kind of rephrase it a little better.
Yes.
Thank you.
I think that's basically the last part of it. You know that there is video out there of a car that's associated and connected to Mr. Chemirmir following Ms. Brooks the day before she was found.
I was made aware of that, yes.
You were made aware that a unique ring belonging to Mrs. Brooks was being sold on a OfferUp account that was possessed by and used by Mr. Chemirmir.
I was aware of that, yes.
Permission to approach?
You might.
Did you then, after hearing all of that information and looking at all the photos from the night, the body-worn camera, the cell phone data, the videos from Walmart, all of that information, did you then choose to change the finding in this case?
I did, yes.
Okay. State's Exhibit 292, is this your full in absentia report?
It is.
293, is that a redacted portion?
I see it, I just want to compare. Yes.
Okay. And then 321, is this the cause of death report then?
Yeah, this is the amended cause of death and manner of death.
Judge will offer State's Exhibit 292 for record purposes, and 293 and 321 for all purposes.
No objection, Judge.
All right, so Lake Exhibit 292 will be offered for record only. Lake Exhibit 293 and 321 will be attended for offer.
Permission to publish?
You may.
Okay, State's Exhibit 293, you place on here just some biographical information of Mary Brooks, white female, 87 years old, date of birth, and then when found. You don't know when can you actually determine when she actually passed away or actually died?
No.
So you just place the time that she was found.
Yes.
And then you go through your the background, which is basically the information that we had just kind of ran through in a synopsis form of how she was found. The groceries are still left out on the not being put away, and then all the biographical information you all have received that night.
Yes, that's correct.
And then in your findings, you go through the information that was presented to you that we just went through, as far as the videos from Walmart, cell phone data, front door being unlocked, her wig being located on the floor near her body, and then the large gold diamond ring being sold on the live auction site.
Yes, that's correct.
Also, there was a sale made on January 31st, including gold and diamonds at the Diamond and Gold Exchange, a local jewelry place.
Right, that's correct.
And then you went through all the videos again and the photographs from that night and changed your, and based on all of that information, you changed it to a homicide.
Right, there were some superficial injuries that in and of themselves, don't necessarily mean anything, but when you take into the aggregate of all the information, I was compelled to make a change in the ruling.
You had noted that she might have a bruise on her head, maybe on her wrist, things like that. Today, right now, we don't know when she might have gotten those bruises.
Correct. Yeah.
But you noted them as you would do, as a doctor would do.
Right.
And but the information that you drew upon are these findings and these things that you just talked about.
Right.
And then on State's Exhibit number 321, you have homicidal violence as the reason for this homicide.
Right, the cause of death.
Okay. And could that include smothering as well?
Yes.
And Dr. Bernard, we've already heard from Dr. Danielson, but you would agree that a pillow is a deadly weapon?
It is, yes.
If it's used in this manner and this means?
Correct.
And hands could be a deadly weapon if it's used in this manner and this means?
Correct.
And then, but because we can't really tell for sure which object might have done this, then there are objects that could be unknown or unknowable to the grand jury in making this determination.
Correct. You could have carpeting. It could be a variety of things. Anything that you can obstruct the airway with.
I'll pass the witness.
Mr. Warren?
Thank you. Excuse me. Thank you, Your Honor. Good morning, Doctor. How are you?
Fine, thank you.
My name is Colin Warren. I represent Mr. Chemirmir in these proceedings. Your Honor, now, bro?
You might.
Doctor, you said you've been at Swift for how long?
Well, since 1987, but I've been the chief since 1991.
Okay. And you've been the chief medical examiner in the office. What was your other title? I'm sorry.
Well, it depends on which one you're talking about.
Current
The
one?
director of SWIFT.
The director of Swift. And Swift, as we've heard about, encompasses several areas up there. Is that correct?
Right, it's the medical examiner's office and the criminal investigation laboratory.
Okay. Let me show you in regards to every case that you have that comes into the Swift has a unique number. Is that correct?
Yes, but this doesn't mean that only the cases that are brought to the office have a number. Every case that is reported to the office has a number.
Okay.
And so in this case, initially, it was not brought in, it was called in.
Okay.
And based on the information that was provided and the lack of anything at that time that was suspicious, the death certificate was relegated back to the treating physician.
Okay.
That's what the CD means.
Okay. And this case number, this IFS-18-02321, is consistent with the autopsy as well as the in absentia report besides the CD. Is that correct?
Well, there wasn't an autopsy, but it correlates to the investigative report and then my absentia and inquest report.
Okay.
All the same number.
And have you seen this investigative narrative report out there?
Yeah, I've got it sitting in front of me right now.
Okay.
Yeah.
The gentleman offered defense exhibit number 1.
No objection.
All right, defense exhibit number 1 will be admitted.
Commissioner Publisher.
You might.
Hey, Doctor, so I'm looking at defense exhibit number 1, like you stated, you have a copy of it up there. And this goes back. So explain to the jury what the investigative narrative is exactly.
Yeah, the investigative narrative under Article 4925, certain cases are reportable to the medical examiner's office. And during that time, depending on what information is provided as to whether that case is brought into the office or the death certificate is relegated back to a treating physician. So let me just go a little further.
Yes.
Unnatural deaths would end up with the medical examiner's office certifying. So only natural deaths would be relegated back to the clinicians if they're willing to sign the death certificate based on their treating.
And so, Doctor, in regards to an investigation narrative, Does the ME's office, do they receive that phone call from a law enforcement agency? Is that how that works? Or?
You know, we were called by a police officer contacting our office regarding the death of Mrs. Brooks, that she had been discovered dead at her residence.
And in that, like as we see in defense number 1, it kind of lays out their initial notification and how it came to be. It says Officer Shane Harris with Richardson Police Department contacted DCME, which is the Dallas County Medical Examiner. Is that correct?
Yes.
Okay. And that would have been by phone call in a situation like this. Is that correct?
Yes, sir, that's correct.
Okay. And basically in this report, it just lays out, Doctor, his findings, what he observed when he got there. Is that correct?
Yes, sir, it does.
And when you talked about when you received this information, and especially assessing your the information that you received after the fact in order to provide your in absentia report, you would go back and you would also look at this investigative narrative. Is that correct?
Yes.
Now, and the differences though between those, like some of the things Mr. Fitzmartin had asked you about that's contained in State's Exhibit number 293, like for instance under findings number 3, it says defendant's front door was unlocked when her grandson arrived to check on her welfare on January 31st, 2018. That information was also contained in that investigation narrative. Like Officer Shane Harris had that information on that night, correct?
He may have had it. I don't believe it's in this original report.
And you understand that, you know, as Mr. Fitzbarnes pointed out, some of the evidence that the jury has seen was the body cam of Officer Shane Harris that night. You know, so it says then on number 4 that the decedent's wig was located on the floor near her body, which was also seen by the jury. But that's information that you used in your absentia report. Is that correct?
Well, it's putting together all the information we had and putting it back together again to gain the totality of the impression that I had.
Correct. And then, were you also, let me ask you this, Doctor, did you ever see those video clips of Officer Shane Harris's body cam?
I saw a body cam video.
Okay. And did you see the one where he, on his own volition, he decided to make further inquiry in regards to any injuries he may or may not have seen on Mrs. Brooks? Did you see that?
I think that we have in our report that he didn't see any.
Correct. So my point is, Doctor, is that in regards to your in absentia report and the investigation narrative or the information that was actually received on January 31st of 2018, the only information that you received different is the information you received from law enforcement about some outside things, correct?
Other than the video that I saw, which would be me personally viewing it. But yes, it would be investigative information.
Okay. Now, so Doctor, without those things, you'd have continued to be filed and held as a natural death, correct?
Right. Without investigative information to redirect our concern for the case, you're right.
Because nothing of the findings, your medical findings, or even the findings of the police department on January 31st, 2018, led anyone to believe otherwise, that it was just a natural death, correct?
Well, that's what was initially thought to be the case at that time.
And Doctor, is it typical for findings such as these to be changed or altered just based on the fact of outside information, but nothing scientifically or medically found that would differ from the initial findings of the report?
That would depend on the particular case. So, I mean, I'm not sure I can really answer your question. I mean, we may get phone calls, we document it, and if it doesn't compel us to reevaluate the case, then it may be documented, but we don't change anything.
Because, I mean, you would agree with me almost anything is possible, correct?
Well, that's a big question, so I guess I'd have to say about anything's possible.
So, like, there are other reasons why some of these things that you've relied on to make this in absentia report that can be outside of the state's case in regards to jury being missing and things to that effect. Like, you've been around in medical examiner, you understand certain times someone may die, people may come in and take things prior to law enforcement arriving, family members have taken things. So there are reasons why certain things may be missing.
Well, in a general sense, that's a true statement.
Right. Thank you, Doctor. That's all I have.
Any more questions, Dr. Bernard?
Yes, Judge. So Dr. Bernard, have the police in other cases and at other times, have they brought you suspicious activity and you've not agreed with them and made your own ruling?
Oh, yeah.
That happens all the time, right? Well, maybe not all the time, but it happens from time to time.
Well, I mean, they may come in with an opinion, and unless I feel like that I believe their opinion or the investigative information is compelling, I may not change anything.
Okay. And the defense exhibit number 1, in showing this is the report that was generated the night or the day after, or closely after the January 31st finding of Miss Brooks, right?
Correct.
And it's based on the information that was delivered basically over the phone to one of your medical examining investigators.
That's correct.
And at that time, we can see in here the scene observations. And it's basically the same thing that you've got in your in absentia report about what Officer Harris viewed that night, correct?
Correct.
And then it goes through the medications and then other information that's found. And it talks about the groceries being out. And it talks about the state of her body and that there's a little bit of blood coming out of her nose and things of that nature, right?
Right.
But there was nothing at that scene, nothing left behind that 3 experienced police officers would look at and determine that someone had done something of foul play.
That's correct.
Had they had that inkling, had they thought that something had been left behind or something looked suspicious, would you have then sent someone out and the medical examiner's office treated it differently?
Well, in this case, it was after, I believe, a daughter came in and identified that there was something missing in the house, that then she filed a report. Had we had that right off the bat, had someone, the grandson who found her, said that there was a missing safe or whatever was missing, we would have probably not only sent someone out, we'd probably brought the case in.
And don't you think the police would have treated that a little bit differently as well?
I think so.
And are there unattended deaths of elderly individuals in Dallas all the time, or a lot of the time?
Well, we have somewhere around 9,000 or more cases that we don't bring in because otherwise we would end up with like 15,000 cases coming to the office. That's untenable. No office can handle that. So you have to make decisions based on those cases, the findings, and the medical history of which cases rise to the level that they need to come in to be examined.
So the scene as it was left that night left the police, experienced police officers, to believe nothing, there was no foul play, and therefore you all had to treat it the way you would a normal situation where an elderly individual had passed away.
That's correct.
And then later on, as things develop and as information becomes known and suspects are developed and more information is gathered, you can then go back and reassess the information you had on the 31st and maybe call it a different way like you did in this situation.
You know, we've done that not only in this case, but in previous times since I've been at the office.
I'll pass it on.
Nothing further, Your Honor.
All right. May Dr. Bernard be released?
Yes, Judge.
No objection, Your Honor.
All right. You may step down. Thank you, Doctor.
Thank you.
Your Honor, ladies and gentlemen of the jury, the state of Texas rests its case in chief.
Thank you so much. So at this time, can I see the lawyers at the side, please?